welcome back to the Compliance Kitchen podcast. Today I want to look at the recent EU news. The Advocate General issued a legal opinion on the EU Blocking Statute or Blocking Regulation. So if you're doing business in the EU or with the EU, this may be something for you to check out in more detail. This is in connection with the Bank Melli Iran versus Telekom Deutschland litigation. And so the European Advocate General, or the AG, issued this opinion recently, I think it was June 4, in regards to this litigation. And the opinion is persuasive, so it's not binding on the Court of Justice of the European Union. However, it does indicate that the EU may be leaning towards a strict construction, so to speak, of the EU Blocking Statute, especially as it concerns the opposing sanctions that come from the US on Iran and Cuba. So by way of background on the EU Blocking Statute, it prohibits EU businesses from complying with certain extraterritorial US sanctions that target Iran and Cuba. Now, the statute also gives EU businesses some legal recourse in the event that they incur losses due to the conflicting US sanctions application. And so while there is some potential legal remedy available, the EU businesses that conduct have business relations both in the EU and with Iran and Cuba, and they're also doing business with the US, or they are banking through the US banking system. They often find themselves in an impossible situation, trying to comply with both regulations that are basically opposing each other. So the Bank Melli versus Telekom Deutschland case is one example of this conflict. Telekom terminated its contract with a German branch of an Iranian bank in 2018. This was after the US stepped up its Iran sanctions, and the bank, this Iranian bank, became landed on the SDN list. So the bank took the position that the termination resulted from the U.S. sanctions, right? That Telekom Deutschland was trying to comply with the U.S. sanctions, which runs up against the this EU blocking statute. So the AG, in his legal opinion, took a number of positions, and I kind of picked out 2 bullet points, but if this is relevant to your business or if you're interested, I suggest that you read the entire opinion, because it's much more in-depth, obviously, than what I can cover here. But basically, the terminating party has to demonstrate that the decision to terminate a contract is unrelated to the U.S. sanctions. So the burden of proof is on the terminating party. And EU member state courts must order continued performance if a contract was terminated unlawfully, as in due to the US sanctions. And the EU member states are to provide for effective, proportionate, and dissuasive sanctions in the event of a breach of the EU blocking statute. Now, again, this opinion is merely persuasive. It's not binding, but I think it's a good data point to kind of follow and see how it's going to develop as the EU courts may take it and kind of head down the strict construction interpretation of the EU blocking statute in future cases. So again, I have a post on compliancekitchen.com if you need to quickly locate the opinion and also the blocking statute regulation. I have links for that to hopefully make it easy for you guys. All right, so that's it on this one, and I look forward to having you on my next episode.